welcome all of you this morning to the opening session of the World Law Congress 23, excuse me. And of course, we look forward to seeing all of you back here on July 20th and 21st at the biannual World Law Congress. Having participated in the last two, one in Madrid and one in Barranquilla, Colombia, I can assure you that your attendance will be something you will be very, very happy that you made the commitment to, because you'll hear from phenomenal speakers, incredible networking opportunities, and really a unique opportunity to discuss challenges to the rule of law throughout the world. Now, of course, many of you know the World Law Association was created by the American Bar Association when Charlie Ryan was the ABA president. And you will see many of them distributed throughout the room is the program of the original World Law Congress held in Athens in 1963. It's a fascinating historical piece. You should all take a moment and look through it. And now it's my pleasure to introduce Javier Cremades, who is the president of the World Jurist Association, who unfortunately is not able to be with us in person today, but is here with us on video. Javier?
Good morning to everybody. It is my pleasure to welcome you to this gathering where we are going to start a journey up to July 2021st, where we will celebrate the most important conversation of jurists on earth. The World Law Congress will take place in this city, in New York, on that occasion. And we will celebrate the 6th anniversary of the first World Law Congress that was celebrated in Athens 60 years ago. As that time, the world is struggling. We really have a difficult time to promote and preserve the rule of law, even within democracies. It is, for that purpose, much more needed than ever to join forces and explain to everybody what is the meaning of living under the rule of law, or what is the consequences of not having the rule of law to protect our freedom and our dignity. There are many forces trying to deteriorate our systems, and the only way to preserve them is to get the community with institutions working together to promote constitutions, liberty, and the rule of law. We are here only for that purpose, honoring the work that previous generations did through the World Jurist Association that was created by two incredible individuals, the legendary president of the American Bar Association, Charlie Ryan, still the youngest ABA president ever, and L. Warren, also an historical figure of law in the world. The Chief Justice of the United States took care about the first World Law Congress in Athens and was pursuing this goal until he died, just calling to jurists from around the globe, India, China, South Africa, any country that was threatened by the rule of force, which is the alternative at the rule of law. Either we are governed by laws or someone, an autocrat, an ideology, a party, any system will take care of our lives. So let's join efforts. Let's do anything we can do to promote the idea that the rule of law is the only way to preserve dignity, freedom, and peace. I also want to thank you, all of you that are present in this gathering in New York at the United Nations headquarters building. Ambassadors, Senator Bob Menendez, Chief Justices from different countries, Richard Wagner, Chief Justice from Canada, Luc Lapresen, President of the Constitutional Court of Belgium, Henry Molina, President of the Supreme Court of Dominican Republic, also awardees of the medals, President Ignacio Sanchez Galán from Iberdrola, Kerry Kennedy, President of the Robert Kennedy Human Rights Foundation, Luis Almagro, Secretary General of the American Organization of States, all of you that are working for the World Law Congress, really thank you. Thank you for your time, for your effort in promoting this idea that is today much needed forever. Finally, let me welcome all of you that are working in the first panel, which is going to be in one of the most contemporary challenges that we are facing. Very interesting, talking about rule of law, corporate governance, and environment. So the rule of law is protecting us and is also giving us a framework to operate. But corporate governance is going even beyond that. It's a soft law that many companies are struggling to not just fulfill with the rule of law, but go a bit more farther and really promote human rights, protect the environment, and work for the good in the society, in the world. At the same time, we are all facing incredible challenges. So let's hear what Judge Preston from Australia, or Luke Laverson, the President of the European Associations for Judges for the Environment, or Santiago Martinez Garrido, General Counsel of Iberdrola, or Secretary Ernest Moniz, who took care of this matter with the first government of President Obama. So let's hear that under the moderation of Susan Coleman, President of the New York City Bar. I also want to thank you, all the members of the World Law Foundation trustees, which are present here today, Hilary Bass, Patricia Lirifo. I want to also thank my colleagues, Diego Solana, Gabriel Fernandez, Teodora Toma, Leopoldo Lelo, and Teresa del Riego, who has been also working hard to make this happen today. So just enjoy this first panel, and then we will go for the celebration of the different medals who will be presented today. Particularly thanks to Brad Carr, President of Paul Weiss, one of the leading law firms in the world, and trustee of the World Law Foundation. Particularly thanks to Stephen Breyer, Associate Justice, retired Justice of the United States Supreme Court, who has been always available for any cause which is promoting the rule of law. And particularly thanks to all of you that are attending digitally or presentially today, this launching of the World Law Congress, New York, July 2021. Please come and see and join us to promote the rule of law around the world. Thank you very much.
Thank you, Javier. And before we start with our first panel, it is my pleasure to introduce Brendan McGuire, who is the Chief Counsel of Mayor Eric Adams of the City of New York. Welcome.
Good morning. As Hillary mentioned, my name is Brendan McGuire, and I serve as Chief Counsel to the New York City Mayor Eric Adams. On behalf of the Mayor, welcome to New York, and thank you for bringing such beautiful weather. It's been a long winter. For those of us in the room who are trial lawyers, we can certainly relate to that technical glitch. I may have trouble sleeping tonight, but nevertheless. The Adams administration is excited for the city to be hosting this opening session of the World Law Congress. This gathering marks another step in our city's recovery from the challenging period of the pandemic. The values of the World Jurist Association are synonymous with the values of New York: diversity, cooperation, dedication. As Mayor Adams likes to say, the city is not coming back. We are back. And the gathering of such a prominent and distinguished group of lawyers, judges, and leaders in what we lawyers here in New York humbly refer to as the legal capital of the world is compelling proof of that. It is impossible to overstate the importance of the work of the WJA since its founding 60 years ago. Unfortunately, our collective commitment to protecting the rights of all people is as essential today as it ever has been. And New York City continues to lead by example in its commitment to the rule of law. From its talented, independent, and dedicated judges on the federal and state levels, to our tireless, creative, and forward-thinking attorneys practicing in every area of the law, to the hardworking paralegals and court clerks and support staff who ensure that our legal system functions each and every day, the city demonstrates the power of the rule of law, the power to bring justice to victims, the power of individual citizens to challenge government, and the power to attract businesses from around the world. It is a system that I have always felt privileged to be a part of. In a prior chapter of my career, I was a federal prosecutor here in New York, focused on public corruption and national security issues. And every day, that work depended upon the mutual cooperation of countries across the world who shared a commitment to the rule of law and to the categorical rejection of violence as a political tool. It is that same shared commitment that you all honor by your presence here today. And as a prosecutor, I used to walk by the New York State Supreme Court courthouse just a few miles from here in Lower Manhattan, which was built nearly 100 years ago. And I was always struck by the inscription on the front of that courthouse, which contained a very simple, but I think profound message. The inscription read, "The true administration of justice is the firmest pillar of good government." And never before has that principle been more important here in New York, in the United States, and of course across the world. So thank you all for your commitment to a world ruled by law and not by force, and for deepening that commitment here together in New York. We wish you all a productive session. Thank you all for being here.
Thank you, Brendan, and please thank the mayor for his warm welcome. It's now my pleasure to turn the program over to Susan Coleman for our first panel. Susan is the president of the New York City Bar Association, and for those of you who may not be aware, that bar association probably has more members than many states have members of the bar. So thank you in advance, Susan, for all the help and cooperation of the New York City Bar with both this Congress and the upcoming Congress in July. Thank you.
Thank you very much, Hillary, and good morning, everyone. It is my pleasure to act as moderator for our panel this morning on the rule of law, corporate governance, and climate. The 80-degree weather should give you some sense of how important and urgent this issue is. As we are all, I'm going to set the stage a little bit. As we are all well too aware, we are living in a world increasingly affected by climate change. There are growing occurrences of natural events and an increasing need to transition to a low-carbon economy. Investors, corporations, and countries are focusing on net zero transitions. With growing awareness, access, and disclosure, countries and corporations are being challenged and held to account for climate mitigation pledges and consequent environmental impact in a variety of ways. In some jurisdictions around the world, mandatory sustainability reporting and corporate disclosure of climate risk is and will increasingly become the norm. Corporate governance must consider and address climate risk, how to meet and address disclosure obligations, and along with that, attendant climate litigation risk. There has been an upward trend in climate litigation over the last several years. It's been reported that until 2017, the total number of climate litigation cases was 884 across a total of 24 countries, with 654 of those cases being brought in the US. By 2020, this number nearly doubled to 1,550 cases across 38 countries, and of course it's increasing, as you are going to hear. We have an amazing panel this morning to address these really critical, pressing issues, and let me start briefly by introducing them to you. They will each speak for several minutes, and hopefully we'll still have time for some questions at the end. First, on my far left, Justice Brian Preston. Justice Preston is the Chief Judge of the Land and Environment Court in New South Wales. Justice Preston is a Vice President for Oceania and the Global Judicial Institute on the Environment, as well as an adjunct professor at 3 Australian universities and a visiting professor at Durham University in the UK. He's the author of the first book on environmental litigation in 1989 and over 150 articles, books, and reviews on environmental law. And then to my far right, Judge Luc Leverson is president of the Constitutional Court of Belgium, a position he has held since 2020. Judge Leverson was first appointed to the court in 2001. And since 2000, Judge Leverson has served as chairman of the Environmental and Energy Law Center at Ghent University, a member and chair of the working group Product Standards of the Belgian Federal Council for Sustainable Development, and president of the EU Forum of Judges for the Environment. To my immediate left is Secretary Ernest Moniz. Secretary Moniz is an American nuclear physicist. From May 2013 to January 2017, he served as the 13th United States Secretary of Energy in the Obama administration. He was founding director of the MIT Energy Initiative and is the MIT Cecil and Ida Green Professor of Physics and Engineering Systems, Emeritus. Secretary Moniz is currently co-chair and CEO of the Nuclear Threat Initiative, as well as president and CEO of the Energy Futures Initiative, a nonprofit organization working on climate and energy technology issues, which he co-founded in 2017. And finally, to my immediate right is Mr. Santiago Martinez Garrido. Mr. Martinez Garrido currently serves as General Secretary and Secretary of the Board of Directors and Executive Committee of Iberdrola. He has served in a variety of positions at Iberdrola, and he has also served as Chief of Staff of the Secretary of State for Justice and Chief of Staff of the Ministry of Justice, and has been a member of various boards of directors of public and private companies. I think you'll agree with me that this panel should be able to solve the issues we are here today to address. And with that, I am going to turn it over to Justice Preston to begin.
Well, thank you very much for inviting me. It's a great pleasure to be here. If only we could solve the problems in the next few minutes. But tackling the existential crisis of climate change requires ambitious action by corporations to reduce greenhouse gas emissions from human activity. The goal is to achieve net zero emissions. That's a balance between anthropogenic emissions by sources and removals by sinks. While there's been much discussion of states' climate change obligations, there has been, until recently, limited discussion of corporations' climate change obligations. This is concerning given that the corporate sector is primarily responsible for global greenhouse gas emissions. Various studies have shown that corporations are falling short in reducing their greenhouse gas emissions at the pace required. One study is by the United Nations High-Level Expert Group on the net zero emissions commitments of non-state entities, that is, including corporations. And it was tasked with addressing the net zero commitments of these non-state actors. They set out various recommendations to bring integrity, transparency and accountability to non-state entities' net zero commitments. Litigation is being increasingly brought to hold enterprises and corporations to account for their inaction or inadequate action to address climate change. While climate change litigation has historically focused on cases against the so-called carbon majors, cases are increasingly being brought against a broad range of corporate actors, including in the plastics, food and agriculture, finance and transport sectors. Climate litigation aims to influence corporate action to reduce greenhouse gas emissions, firstly from the corporation's own activities, both in relation to high emitting projects, but also carbon intensive business, in corporations' supply chain and in their value chain. Litigation has also been brought for climate-related greenwashing, or so-called climate washing, which aims to hold corporations to account for climate change misinformation. I'll deal with each of these categories very quickly. The first is against holding corporations accountable for high-emitting projects. There's been a number of litigations brought against projects that will be a major source of greenhouse gas emissions, such as a new coal mine or a coal-fired power station. These projects are assessed not only against domestic law and policies, but also international law and policies, including the temperature and time targets in the Paris Agreement. Examples are in Australia in relation to the Gloucester Resources case, which I decided, and the Waratah coal decision, which the Queensland Land Court decided. Secondly, there's been actions against corporations that have a carbon-intensive business. And the best example of that would be the Miller de Foncy case against Royal Dutch Shell in the Netherlands. So there, the plaintiff sought a ruling from the court that Shell must reduce its greenhouse gas emissions by 45% by 2030 compared to 2010 levels, and to zero by 2050 in line with the Paris Agreement. And the Hague District Court so ordered. That decision is subject to appeal. There's also been litigation against Shell's board of directors by an environmental legal NGO, Client Earth, and its claim is that the directors have failed to adopt and implement a climate strategy that aligns with the Paris Agreement, in breach of their responsibilities under corporations law. Litigation has also been brought against corporations for non-disclosure or misleading disclosure of climate-related risks. Examples include one by the New York Attorney General against ExxonMobil. That was unsuccessful. There's been a subsequent case by the Massachusetts Attorney General, also against ExxonMobil, which is continuing. In Australia, there's been litigation against pension funds, we call them superannuation funds, for their management and disclosure of climate-related risks. That litigation has been successful and causing the pension fund to change its approach. Turning to the supply and value chains, there's been litigation on the corporate responsibility for the greenhouse gas emissions in a corporation's supply and value chains. One case, Envelvert, against the French Casino, which is a supermarket chain, has been looking at the involvement of Casino in the cattle industry in Brazil and Colombia, which is its supply chain. And the allegation is that that is causing environmental and human rights harms. But of particular concern is the destruction, the deforestation, which leads to destruction of carbon sinks. As far as the value chain, the Commission on Human Rights of the Philippines issued a final report in 2022 where it found that there was corporate responsibility to refrain from continuing to climate change impacts that impact on the full enjoyment of human rights. They said that that responsibility extends not only to the whole group of companies of each carbon major, but also to its business enterprises in each of the carbon majors' respective value chains. And the final category is the climate washing. So businesses may represent their products or activities to be more environmentally friendly than they actually are. and these representations may give rise to a claim by the customer against the business. There has been considerable action, particularly in Australia, by both the corporate regulator but also by affected customers against corporations for greenwashing. Examples against General Motors and Goodyear in relation to tyres. There's also been actions for misleading advertising. So examples include Client Earth's complaint under the OECD guidelines for BP's advertising campaign. In New Zealand, an action against First Gas Company for its misleading advertising campaign about it having net zero gas, which was upheld. And there has been its current litigation in Denmark against Danish Crown, which is the EU's largest pork producer, for its said to be misleading advertising that pork production is climate controlled and more climate friendly than you think. In France, there's been current litigation against Total Energies for its rebranding campaign, saying that its claims to aim for net zero by 2050 and to become a major player in the energy transition are false and misleading. These are just some examples. So performing its essential role in holding the corporate sector to account legally, the judiciary upholds the law and the rule of law. Now, where that law promotes taking mitigation action to reduce greenhouse gas emissions by sources and to increase removal of greenhouse gases by sinks, or by taking adaptation action to address the consequences of climate change, the judiciary's decisions facilitate the achievement of effective climate action. Thank you.
Thank you very much, Justice Preston. And now I'm going to turn it over to Judge Laverson, who will speak about the adjudication of climate change cases by constitutional courts in Europe and the European Courts of Human Rights.
Thank you, Madam Chair, for inviting me and giving me the opportunity to share with you some recent information. With the rise of global temperatures, and this is illustrated, I think, by the record high temperatures we have for the time of the year here in New York, we also witness a rise of climate litigation worldwide. The climate change litigation database of the 7th Center for Climate Change Law at Columbia Law School here in New York includes now, and to be precise, last week Thursday when I looked at it, 1,572 US cases and 686 cases from over 55 other countries, including climate litigation cases brought before international or regional courts or tribunals. The major part of them are cases brought against governments, but also cases brought against corporations, as has discussed by Justice Preston, are recently on the rise. The database distinguishes 12 different categories of climate change cases against governments, under which cases based on human rights, including constitutional rights. And during the panel at the World Law Congress in July, I will have the opportunity to discuss in more detail constitutional issues, as the separation of powers and the rule of law, in more detail in this field, and to present also the case law of my own court in this regard. In this short intervention, I would only like to inform you of some important developments in constitutional and human rights case law in Europe. As constitutional jurisprudence is concerned, I should refer to the very important judgment of the German Constitutional Court, the Bundesverfassungsgericht. In February 2020, a group of young German people filed a legal challenge to Germany's Federal Climate Protection Act, arguing that it was insufficient. On April 29, 2021, the Federal Constitutional Court, in the so-called Neubauer case, struck down parts of the Climate Act as incompatible with fundamental rights for failing to set sufficient provisions for emission cuts beyond 2030. The court found that Article 20A of the Federal Constitution of Germany obliges the legislature to protect the climate and it aims at achieving climate neutrality. The court stated that Article 20A is a justiciable legal norm that is intended to bind the political process in favor of ecological concerns, also with a view to the future generations that are particularly affected. Accepting arguments that the legislature must follow a carbon budget approach to limit global warming to well below 2 degrees Celsius and, if possible, to 1.5 degrees Celsius, the court found that the legislature had not proportionally distributed the budget between the current and the future generation, saying that, and I quote in translation, one generation must not be allowed to consume large parts of the carbon dioxide budget under a comparatively mild reduction burden if this would at the same time leave future generations with a radical reduction burden and expose their lives to serious losses of freedom. The court ordered the legislature to set clear provisions for reduction targets from 2031 onwards by the end of 2022. Following that ruling, and with a view to the meanwhile new adopted European climate targets for 2030, the German federal government presented amendments to the Climate Change Act that were adopted by the German parliament in June 2021, and they entered into force in August 2021. Since 2020, no less than 14 cases in which it is argued that parties to the European Convention of Human Rights are violating human rights by not taking sufficient action to combat climate change have been introduced to the European Human Rights Court in Strasbourg. 3 of those cases have been relinquished to the Grand Chamber of that court, and 2 of them have been heard 2 weeks ago. The 3rd one will follow. Other cases have been adjourned, awaiting the Grand Chamber judgment in those 3 cases. The European Court of Human Rights has to take very important decisions with an impact on future climate policy and law and litigation, with potential, I think, global impacts. As standing is concerned, the question arises if the applicants can be considered to be victims of violations of their human rights. That's a precondition to have access to the European European Court of Human Rights. And if one need to exhaust, that's in principle another condition, all national remedies before introducing such a climate case before that court, given the fact that the time to act in an effective way against climate change is fast shrinking. I refer to the latest reports of the Intergovernmental Panel on Climate Change. As the substance is concerned, because there is no right to a healthy environment or to a stable climate in the European Convention on Human Rights, the question will be if those articles of the Articles 2 and 8 concerning the right to life and the right to private and family life protect against the harmful consequences of climate change, and if the state parties, so the parties to the European Convention of Human Rights, have a positive obligation to act against it, and to what extent. It's difficult to predict if the European Court of Human Rights will follow or not the approach taken by the Supreme Court in the Netherlands in the so-called Urgenda case, which, when the Supreme Court decided, was based mainly on the Articles 2 and 8 of the European Convention of Human Rights. Whatever the European Court of Human Rights may decide, I believe it will have for sure a great impact on future climate litigation. But as long as governments are not living up to the commitments taken under the Paris Agreement, I believe that climate litigation will not go away for the next decades. Thank you very much.
Thank you so much, Judge Leverson. And with that, I'm going to turn it over to Secretary Muniz, who will speak about the situation in the U.S., recent U.S. litigation, and the industrial strategy implications in the U.S. and Europe.
Well, thank you, Susan. Yeah, I will, as she said, Susan said, focus mainly on the words climate change in the title of this panel, but I don't mean to minimize in any way the words rule of law and corporate governance. For example, a couple of rule of law issues that I think have not really been raised is what's the law? I'll come back to that in the U.S. context, where we have a law, but we don't know what it means. A second issue that I think will come into play eventually in the United States, as it has in Europe, in effect, is in 1992, the United States did establish a law, it's called the Rio Treaty, passed by the Senate, signed by the President, to address anthropogenic climate impacts. It just hasn't been defined what that means, but I think the European examples, in a certain sense, help interpret whether one is meeting one's obligations. On corporate governance, risk disclosure has been mentioned. I won't repeat that. Susan mentioned that in the introduction, for example. But another very hot issue, unresolved, is the whole question of will there or will there not be liability for past operations, a very big issue, with some arguing for going back to the Industrial Revolution. And in COP27 in Egypt, we saw loss and damage, which was corporations and governments. But these are big unresolved issues that will have huge impact. But let me turn again mainly to climate discussions. In the United States, there was a remarkable, I think most of you know this, a remarkable 9 months of passing 3 major laws of relevance in this discussion. The Bipartisan Infrastructure Law, the CHIPS and Science Act, and the Inflation Reduction Act, which, by the way, the IRA did everything right except reduce inflation. But those laws together, I'll focus on the issue, is they are, for the United States, certainly, and I would argue for others as well, a rather breathtaking leap forward, good or bad, in industrial policy. It's so sensitive that we refer to it more delicately as industrial strategy these days, but it is industrial policy, plain and simple. I would assert that industrial policy in the United States, in Europe, and we could go on, is essential to meet any reasonable in the climate context, goals for 2030. However, we should not confuse necessity with success. The implementation of those laws is really what's in play today. And I would say there are some hopeful signs there, and lots of warning flags in terms of the ability to overcome the checkered history of trying to implement industrial policy outside, at least outside the military industrial complex, where there has been bipartisan support. Some of the success, a couple of successes maybe, well, one I would mention is that the IRA has had a profound effect, I believe, in moving forward the hydrogen economy, hydrogen market formation. Possibly it's had that success because no money has been spent yet. It just called for proposals and received an overwhelming response, with every part of the country looking at how it might get engaged in hydrogen demand and, of course, associated supply. Hydrogen hubs put forward as the centerpiece precisely to minimize infrastructure requirements by bringing suppliers and users together. So that's an example of, I think, progress, but lots of issues. For example, I mentioned earlier on in terms of rule of law. What's the law? Congress passed 3 laws, as we said. As usual, Congress did not define what they actually meant. And so the Department of Treasury, let's say for tax incentives, $270 billion of tax incentives as scored by the Congressional Budget Office, very, very little rule-making. What does domestic content mean? What are environmental justice communities? All of this is actually to be defined by the Department of Treasury, and those rules will have enormous impact on the implementation of what is called law in this country. To turn to the IRA and Europe, clearly many in this room are quite aware that there have been many complaints from Europe about especially the IRA and things like its domestic content requirements, et cetera. I don't want to sound too crude, but my answer to my European friends starts out with, get over it. Because number one, we all need the United States to step forward in climate. This is the biggest step we've taken. And whether it's the United States or Europe or elsewhere, there are political realities. Those issues that are being commented on, frankly, is bluntly the political price for getting a law. It, however, has had what I consider to be the salutary effect of having Europe examine its own laws and regulations and rules. Things like state aid, for example, which, as an American I will comment, looks to me like a relic of early days of the European Union. But I think what's really important, and here I show my inherent optimism, I believe that what's happening in the United States, in Europe, and in some ways elsewhere as well, with these industrial policies, I hope and believe we will, in some time, 5 years or 10 years, look back at as the chaotic beginnings of our working together to define much better hygiene for supply chains. None of us can ignore the fact that we have done a horrible job in terms of creating exposure to supply chains of national interest. And I believe this can be now channeled, I hope, as I say, towards a positive outcome. And I would be even now maybe going beyond optimism to being Pollyannish, suggest that it wouldn't be a bad idea to eventually get China in that discussion as well. Frankly, it's in all of our interests to have better hygiene in our supply chains. Finally, let me just mention very briefly finance. Actually, I would argue many issues of finance are major barriers to the flow of the kind of pace and scale of private capital that we need in these arenas. In the United States, we just said again several times, we have these 3 laws. Even after they are interpreted by the Treasury Department, they will still be insufficient for removing policy and regulatory barriers to large private capital flows. And the scale of this looking forward is daunting. The IEA, for example, International Energy Agency, for example, talks about it, and they're not alone in this, the need for the order of $3 trillion of additional capital flowing into clean energy globally to mid-century. $3 trillion is essentially all the liquid capital floating around today for all sectors, not just clean energy. So the importance of clearing the field here is really important, and we have to start now when we have more capital available than bankable clean energy projects to be prepared for the future. And last, I'll say, in terms of capital flow, critical issue of capital flow to the developing world. This will be a major focus in COP28. This may not be popular with everyone, but I believe discussions like loss and damage are just complicating the situation. We should keep fixated on the issue. The issue is getting large capital flow to developing countries to address in real ways, with additionality and the like, the needed trends towards economic development along with a low-carbon future. We in the industrialized world have done a lousy job defining the rules of the game, and that in turn is a major impediment to getting those large capital flows. That's what we should be focusing on. Thank you.
Thank you so much, Secretary Muniz. So we've heard about litigation, we've heard about policy, and now I'm going to turn it over to Santiago Martinez Garrido, who's going to speak about the need for energy transition, climate goals, and a strong corporate governance against a backdrop of the rule of law.
Thank you, Susan. Now is the time of the corporate perspective. No? Good morning, everyone. And first, I would like to thank the World Jurist Association for invitation to this very interesting and relevant panel. I would like to focus my speech on how, through the company's leadership of good corporate governance, we can advance in the fight against climate change, and to expand with the example of the Iberdrola Group. Today, nobody questions that climate change is one of the biggest challenges that we have. It is also clear that in the energy sector, could play a very relevant, a very important role in order to reduce the emission of CO2. With these two elements, as pointed Parte, under our current scenario, the need to comply with climate goals, the need for a strong corporate governance system, and a strong commitment from the private company, and guarantee the rule of law are essential. To expand the rule of law and institution through the nation of the world is one of the main missions of the World Jurist Association. The rule of law, as Javier explained, is an essential principle of governance in order to develop the country. Under the current situation of energy transition to fight to climate change, the rule of law should give us the clear framework in order to make the investment that we need to do in the coming years. However, I believe that it's necessary to make a difference between compliance with what we are obligated by the rule of law and what constitutes an additional step in our commitment to society. I agree with Javier Comadres when they say at the beginning that it's absolutely different. In my opinion, comply only with what the law prescribes is not good corporate governance. It's just being a good citizen. A good corporate governance means going a step further, voluntarily assuming additional commitments as soft law to those that are strictly compulsory by hard law. And here is where I believe that the leadership of companies is essential in a situation where they can advance more in the fight against climate change. And in the case of companies like the Iberdrola Group, this step further is even more important and involves going further in the compromise and adopting voluntary commitments as soft law that will solve down the climate change crisis. The traditional concept of a company from a purely economy perspective has long since been superseded by a company that addresses in execution not only business plan, but jointly with the triplet perspective, as serving as well as employees, customer, and very important, the society that is served. Because it's not only about our client, but most important also the footprint that the execution of our business plan or strategy will leave on society. Not only based on short-term profitability, but a commitment to continue in the future and a long-term vision. I'm very proud to be able to say that this has been Iberdrola project for years. When Chairman Galán arrived to Iberdrola more than 20 years ago, he has always believed that the environment is a serious matter and understood that Kyoto Protocol would require a deep change in the energy sector, making clear electrification increasingly important. For an electricity company like Iberdrola, the simple thing would have been to continue developing its activity in a traditional way by operating our existing plan and maximizing their profitability and profit. But he decided to define a new strategy plan for the group. And he decided to do that with value, work, ethics, effort, team spirit, loyalty, transparency. At the start, invest heavily in clean energy, close our coal and fuel plants. We have 17 plants of this type. Increase our investment in power networks. Iberdrola today passed from the 20 company to one of the 2 largest utilities worldwide, and largest in Europe, with $75 billion on market cap, after a shareholder return of more than 800% over the period. We are now serving more than 100 million people in dozens of countries, from the United States to Brazil, from Mexico to Australia, Germany, Spain, UK, etc. We also create value for our stakeholders. Mainly, and I think is one of the most social relevant issue, as first mover in the clean energy revolution, we have reduced our CO2 emission to 59 grams per kilowatt hour, 3 to 4 times lower than the average of our peers in Europe and the United States. Our activities sustain more than 400,000 jobs in our 20,000 suppliers, thanks to the purchase worth $18 billion just last year. We have tax contribution more than $8 billion per annum. We are the private utility that invests most in R&D worldwide, more than $400 million annually, according to the European Commission. And we are the largest corporate user of green and sustainability bonds, more than 50 billion euros used to date. And I want to mention all of this because if Iberdrola is what is today, it's clear proof that the change was possible then, but now it's essential to do that. But we can achieve this goal because we believe in our strategy and its development. Because today, we are not talking about the proposal. We are talking about the facts, delivery through more than 20 years. And we can do that because we believe from the beginning that we have a good corporate governance system. It's essential for the credibility of the project and for the growth. Today, it is very common to see that larger companies are assuming commitment to fight against the climate change. The difficult thing was to do it almost 20 years ago, and at the beginning of the century. And to do that as a real informed commitment of soft law, and not a mere programmatic statement or aspirational objectives. But for this, it was essential that this was included in the internal regulation of the company in order to ensure its enforceability. Iberdrola environmental, social, and good corporate governance agenda has been one of the cornerstones of the company. With the support of the impetus of Chairman Galán and the design and execution by my predecessor, Julián Martínez y Mancas, Iberdrola has designed a corporate and sustainability system that places in the forefront of the corporate governance, but also the highest level of commitment from the board of directors of a private company or an entry company on the governance model and the energy transition. If the pioneers are those who anticipate, it is clear that Iberdrola is a pioneer, because we anticipate establish an ethical standard. We anticipate apply a compliance system. We anticipate prepare a sustainability report more than 10, 20 years. We anticipate and create the first committee, Sustainability and Development Committee, inside the board of directors. The first company to link its business and sustainability strategy with United Nations 2030 agenda. And the first company that includes in the bylaws the concept of the social dividend. It is the first company that, through corporate policies, assume, among others, the commitment to sustainable management, environmental policy, and climate action policies, thus obliging the board to develop its strategy with absolute respect to the environment and to elimination the greenhouse gases, for which the elimination of fossil fuel in electricity generation is expressly included. And we have the commitment to be net zero emission in 2030. Let me end by saying that an adequate contribution between the rule of law and the corporate governance is the best way in order to fight against the climate change. And that would be real, and it's possible. We want to work in order to have a real sustainable climate governance. Thank you.
Thank you so much. Unfortunately, I think we're not going to have time for questions, but I think that we will all heed Secretary Moniz's advice. We will not confuse necessity with success. We will focus on implementation with corporate governance as a model. We will rely on our courts to make sure that the rule of law makes this place a better place for future generations. Thank you all very much.
It's now my pleasure to introduce three people who are going to briefly talk about the upcoming Congress: Patricia Lee, Victor Oleo, and Aranka Crematas. If you'd like to come to the podium. Aranka, perhaps you could start by, I know you were present when the World Law Foundation gave the award to Justice Ruth Bader Ginsburg. One of the youngest people present. Perhaps you could tell us about that experience.
Well, thank you, Hillary. So I was present when we gave the award to Justice Ruth Bader Ginsburg, so it was a great opportunity to meet her. As a young female law student, it really had an impact on me. So getting to know her firsthand and being able to talk to a woman that has created such a good impact in the world and has always fought for justice and trying to make this world a more fair place, it was very inspiring. Also, I had a chance to have a conversation with her, and I learned a little bit more about her life and her contribution to gender equality, civil rights, and her service as a Supreme Court judge of the United States. And also, I would like to say that as a young person, these World Jurist Association events are very appealing to young people because it gives us an opportunity to get involved in big issues that are going on in the world, issues related to law, to justice, to nation cooperation, progress, human rights. The events are very dynamic, and it is a great forum to meet and connect and dialogue with people of recognized prestige, leading personalities in the legal world from diverse cultures and nationalities. So I want to say that young generations, we want to take action and are very committed into making a better world. Thank you.
Good morning. I'm Trish Rifo. I am yet another former president of the American Bar Association from Phoenix, Arizona. And I will just begin by saying that the fact that we have three current, Hillary, me, and our colleague Jim Silkenet, former presidents of the ABA, and the current president, Deborah Enix Ross of the ABA, from whom you will hear shortly, speaks to what we think about the importance of this organization and in particular of this gathering. Hillary helped us to rediscover the World Jurist Association through the efforts of Javier when she was president of the ABA. And she in turn has revivified with Javier the relationship between these two organizations. They are quite different, but they work together and they serve the common purpose of working toward the rule of law. The Congress is particularly extraordinary, in my judgment, because of, for example, the panel you just saw. The quality of the speakers you will hear from, who are ministers, who are jurists, and who are lawyers from all around the world, will exceed your expectations. You will leave not just inspired, but you will leave with an understanding that all of us as lawyers, wherever we are in the world, share a deep commitment and passion to the basic foundation of the rule of law. And coming together with such a diverse group to be reminded of that every 2 years is a deeply important function of the World Law Congress. So we look forward to seeing all of you again here in July. Thank you.
Thank you, Hillary. Thank you, Arantxa. Thank you, Patricia. I'm Victor Olea, president of the Mexican Bar Association. And first of all, I will initiate by petition of our friend Javier Cremades, making some remarks regarding the rule of law in today's Mexico. The object and purpose of the Mexican bar impose the unavoidable obligation to ensure the full realization and protection of the rule of law, equality before the law, transparency, court independence, and unrestricted access to due process. Without the rule of law, there is no security. It is a fundamental necessity. Let us not allow what many doctrinarians call the decline of the rule of law. Currently, in Mexico, the power demands absolute obedience, and only the rule of law can discipline that craving. Every morning, the President of Mexico attacks the organized Mexican legal profession, calling us conservatives and even traitors to the country. He personally attacks judges, magistrates, and chief justices, accusing them of being corrupt and supposedly acting against the people, even more so when they issue rulings that he does not agree with. He consistently issues bills to limit or nullify different institutions, as just happened with the one related to our National Electoral Institute of great prestige in our country and worldwide. Our rule of law, we must admit it, it's today very weak, very vulnerable, and therefore we have the unavoidable obligation to fight for it. That's why I believe that all of these international organizations, like the World Jurist Association, should be even more committed to the Mexican legal profession, and not only as a matter of affinity. It is a strategic imperative that arises from a convergence of interests, such as achieving not only the rule of law, but also promoting the judicial independence. The current situation of the rule of law in Mexico should engrave two ideas in our memory. No one is safe from the threats of the rule of law and to the freedom of professional practice, and no one should be left alone in the face of them. Finally, that's why it's imperative for all of us to promote the World Law Congress that will take place in this marvelous city of New York the next 20th and 21st of July. It will be the main opportunity to support and promote the rule of law in our world. Thank you. Thanks a lot.
And now it's my pleasure to introduce the current president of the American Bar Association to present the World Jurist Association Awards. Deborah Enix Ross is a native New Yorker, has been serving as our president since August, and I'm happy to report that Deborah and I share a unique record as presidents of the ABA. And in the history of the American Bar Association, this is the first time where you had two members of the same law school class, both ending up as president of the ABA, both graduates of the University of Miami. So Deborah, please join us.
Thank you, Madam President. And thank you all for coming to my hometown. As Hillary said, I'm just a girl from New York City. I grew up in Harlem, just a few miles north of here. And so it is really an honor to stand here before you as the president of the American Bar Association, reflecting on the power of the presidency, because as we've heard, this organization has close ties with the ABA, and it was our past president, Charles Ryan, who helped establish this association and establish this cooperation. He was also the person who went to our then president and asked for the establishment of what we now call Law Day, to underscore the importance of the rule of law as opposed to the rule by law. So the power of one person can make a difference. And speaking of the power of one person, it is my privilege to present the World Jurist Association Medal of Honor this morning to Kerry Kennedy. They want you to come up, but I have these amazing words that I want to say to you, and it's rather long, so if you want to stand, it's fine. Because I think it's, if you're like me, you maybe want to, because it's really important for us to understand. Kerry Kennedy is an American lawyer, author, and human rights activist. Ms. Kennedy has led delegations to El Salvador, Gaza, Haiti, Kenya, Northern Ireland, and South Korea, among other places. In 1988, Ms. Kennedy began serving as president of the Robert F. Kennedy Center for Human Rights. Today, she is the honorary president of the Robert F. Kennedy Foundation of Europe. She is chair of the Amnesty International Leadership Council, and she also serves on the advisory board of the Columbia University Center on Sustainable Investment. As a frequent speaker, Ms. Kennedy calls on her audiences to oppose human rights violations. Her writing has been published in the Boston Globe, Chicago Sun-Times, and the New York Times. In 2017, Ms. Kennedy received the Medal for Social Activism from the World Summit of Nobel Peace Laureates in Bogota, Colombia, for her, and this is a quote, for her impactful efforts on communities throughout the world as a result of her lifelong devotion to the pursuit of equal justice. Ms. Kennedy has indeed devoted her life to equal justice, to the promotion and protection of basic rights, and to the preservation of the rule of law. For more than 30 years, she has worked on diverse human rights issues such as children's rights, child labor, disappearance, indigenous land rights, judicial independence, freedom of expression, ethnic violence, and the environment. She has concentrated specifically on women's rights, particularly honor killings, sexual slavery, domestic violence, workplace discrimination, and sexual assault. She has worked in more than 60 countries and led hundreds of human rights delegations. And that is why it is my pleasure and my honor to present the World Jurist Association's Medal of Honor to Kerry Kennedy.
Thank you. Thank you very much. I'm so honored with this award, and I'm especially happy to be following Victor Olea because your words ring so true, and the issues that you're facing in Mexico are faced by lawyers and judges and people and activists all over this world. So thank you for standing up here and saying that this morning, a brave thing to do. Can we give him a round of applause? Not easy, thank you. When employers in Florida stole from, beat, chained, and locked farmhands in a U-Haul, lawyers for the Coalition of Immokalee Workers in Florida documented the abuses and brought the case to the U.S. Attorney, Doug Malloy. Malloy said what the 6 perpetrators did was, quote, slavery plain and simple, unquote. The grand jury indicted, Malloy sued, and the judge sentenced the perpetrators to 15 years in prison. In 2014, when Uganda passed the world's most draconian anti-homosexuality law, activists protested, lawyers sued, and the judge overturned the legislation. Now, a few weeks after Uganda passed similar legislation, lawyers are again suing, seeking redress in the courts. When the great muckraking journalist Nelson Carvajal was murdered shortly after he exposed corruption, his family hired lawyers. They sued the government of Colombia, and judges at the Inter-American Court for Human Rights ruled the murder a crime against humanity. The ruling in 2019 was the first case in the history of Latin America holding a government accountable for the assassination of a journalist. When law student Claudina Isabel was murdered in Guatemala and the police failed to investigate, her family hired lawyers. They sued. Judges found the government of Guatemala liable for femicide and then ruled that the government must train police officers, create an investigation protocol, establish a hotline named after Claudina Isabel for missing women, pay compensation to her family, and make an official public apology at a press conference to her family. Today, across Ukraine, thousands of lawyers and judges and victim advocates have joined Prosecutor General Andrei Kostin and documented over 80,000 cases of war crimes and crimes against humanity, all stemming from the crime of aggression, for which Putin and his henchmen will be held accountable. You may ask what the World Jurist Association is doing here at the United Nations today. We are here because we share President Kennedy's belief that law is the strongest link between humanity and freedom. We are here to bolster the rule of law, to lay claim to the hard work of lawyers and judges and jurists across this country and around the world who risk imprisonment and torture and death every day, day after day, day after day, because they value dignity and they have faith against all odds that the law is the greatest bulwark protecting freedom. Today, we celebrate that faith and the people who've devoted their lives to protecting it, all of you in this room. For that, on behalf of my colleagues at Robert F. Kennedy Human Rights and all our partners, colleagues and partners engaged in all the cases I just mentioned and many more, I thank you.
I am certain there was no doubt why you were to receive the reward, but if there was any doubt, after that, I know people will understand why, and we thank you for what you're doing, and that, for me, is a call to action to rededicate ourselves to this great work. Thank you very much. It's now also my pleasure to present the award to Luis Almagro, who is a Uruguayan lawyer, diplomat, and politician who has served as the 10th Secretary General of the Organization of American States since 2015. He served as Minister of Foreign Relations of Uruguay from 2010 to 2015. Secretary General Almagro served as Uruguay's ambassador to the People's Republic of China from 2005 to 2010 and had previously held various positions at the Ministry of Foreign Relations. During his tenure as Uruguay's foreign minister, the country received several detainees from the Guantanamo Bay detention camp and dozens of Syrian refugee families, and it maintained a military presence in Haiti to support reconstruction after the 2010 earthquake. After leaving the administration, Secretary General Almagro was elected Senator of the Republic and assumed his seat in March 2015. He resigned a few months later to take office as Secretary General of the Organization of American States. In March of 2020, the OAS General Assembly re-elected him in office for a second term until 2025. Secretary General Almagro has collaborated with the WJA since 2019 and attended its congresses, giving visibility to global problems of law and society. And therefore, it is my pleasure to present the WJA Medal of Honor to Secretary General Luis Almagro.
It is a rare honor to be honored by you, the World Jurist Association. In fact, it is a twofold source of pride for me, not only as a lawyer, but also as Secretary General of the organization that brings together all the countries of the Americas. The task of defending and promoting respect for the international legal order is not easy in the current circumstances. That is why it is gratifying to receive this recognition. Respect for international law is the basic underpinning of the inter-American system. For nearly a century and a half, the countries of the Americas have built a foundation of law that unite us and which we have undertaken to abide by and to enforce. Unlike any region, the Pan-American Union and the Organization of American States, the countries of the Americas have pledged that their governments would be democratic, with all that entails: respect for human rights, separation of powers, rule of law, periodic free elections. However, they also place the burden of meeting those responsibilities on the organs of the OAS, starting with the General Secretariat. We have been committed to this from the day we took up our duties, and we have never shirked this obligation. The region keep seeing breakdowns in the democratic order, keep seeing crimes against humanity, keep seeing human rights violations, keep seeing tortured people, keep seeing political prisoners, keep seeing missing people. Nothing can silence us from denouncing that. Defending democracy and human rights cannot be labeled as interventionism in domestic affairs. We need to do it permanently. We need to make this visible, and we need to make the law respected. At every turn, we have put duty before any other interest. The only way to achieve a better world is through coexistence based on a common, just legal order. Respecting the fundamental freedoms and guarantees, respecting the environment, fighting climate change, fighting harder against corruption. I accept this recognition as an encouragement to continue promoting respect for the law that is common to all of us. I value it all the more because it comes from you, the women and men of law from all over the world. Rest assured that, in accepting this award, I renew my conviction to defend our democratic institutions and struggle for full respect for the law. Thank you.
And now I would ask Secretary Muniz to come and present our next award.
Sorry, a bit of an obstacle course to get here. Well, thank you very much for this opportunity. Really, it's a great pleasure to introduce Ignacio Sanchez Galan, my friend and executive chairman of Iberdrola and recipient of the Medal of Honor of the WJA. I have to confess that Ignacio was kind enough a decade ago to come to an award ceremony in Madrid at his alma mater, Comillas University, that I was part of. And so I feel this is like leveling the playing field now in terms of doing that. But actually, even much more important than that is the fact that it's an opportunity to recognize really a pioneer in the renewable energy revolution, and I think that's a fair use of the word that we have seen in the last 20 years. For addressing the global climate challenge that, of course, we addressed this morning and has been said by many to be a massive challenge for us to address. And then we heard also about the leadership in corporate responsibility that is part and parcel of success in this enterprise. Now, in discussing the climate challenge, many of you, I'm sure, are aware that the lead horse, if you like, in that race to decarbonize is clean electricity. In fact, clean electricity is in many ways, one might say, the only bright spot right now in terms of really having made significant progress in decarbonization in the industrial countries in particular. There are supply options and wind and solar in particular in the renewable space have had dramatic increase in deployment associated with dramatic decrease in cost over this time period. And now being supplemented by electricity storage, especially batteries, so far at least, that can address some of the variability of wind and solar. But we also know that electricity decarbonization, that is electricity sector decarbonization, will not by itself lead us to where we want to go. We've heard net zero discussed, for example. Electricity responsible for a quarter to a fifth of emissions. But what we are seeing now is the beginnings of having electricity decarbonizing and providing important services in some of the sectors that have very high emissions. For example, the highest emitting sector is transportation, and now we are all seeing around us all the time the big buzz around electric vehicles, at least for light-duty vehicles. And just yesterday, I'm not saying I believe this, but just with the new, in the United States, with the new Environmental Protection Agency rules, we see rather grand statements about, 2/3 of the automobiles on the road in 2030 will be EVs. Well, I'll take a half. I'll take a third, actually, but it's really dramatic. And in some states here, but in Europe, we see very, very strong commitments in terms of the transition. So that's another example where electrification of other sectors is clearly going to have a major role in decarbonization. And I will say that another example would be that we are going to need something like a fuel as a complement. Well, now we have hydrogen coming along. We mentioned that earlier in the panel. And once again, hydrogen, green hydrogen, hydrogen produced from those same renewables, wind and solar. Again, now it's very early stages, but still starting what looks to be a very, very strong trajectory. So that now brings us back to Ignacio and Iberdrola, because he and the company have certainly been a big part of this picture that we have outlined up to now and moving forward into the future. He was a pioneer. Ignacio was a pioneer, really, in making all this happen. In 2001, I think I have this right. You can correct the record. 2001, he became executive vice chairman and CEO at Iberdrola. 5 years later, becoming the executive chairman, the position that he holds today. And I would say, and I say this in a room of lawyers as a compliment, as an engineer, he entered this job with a can-do attitude that, frankly, transformed, I hope I'm not offending anyone, but I would say what was at that time, more than 2 decades ago, an ordinary Spanish utility into a global powerhouse. And that is quite remarkable. I think Ignacio, again, as an engineer, he was out to change the electricity industry, not just to build Iberdrola, but to build Iberdrola while benefiting from that change in the energy industry, in the electricity industry. So today, starting then, actually well before it was popular, starting the strong commitment to renewables more than 2 decades ago, I think was a great exercise of vision, of commitment, of some risk. I'm sure there were lots of discussions about risk management at that time, but certainly demonstrating that today, as we say in the United States, green is green. You can do well by doing good as well. He's wearing green. There we go. I should have worn my green tie. That's right. Anyway, so this focus was really tremendously important and really a catalyst, I would say. Today, wind and solar are about 14% of U.S. electricity. It wasn't long ago we were talking low single digits. This is growing remarkably. It's third behind natural gas and nuclear in terms of electricity kilowatt hours produced today. But a year ago, it was bigger than nuclear. In April of last year, it was 20% of electricity. So it really shows how it's growing. And today, we have, I think, let's see, it's around 200 plus gigawatts, 1,000 megawatts, for those not into the giga world, more than 200 gigawatts of wind and solar deployed. But every model, including our own, that looks at 2030 and looks at meeting responsible climate goals on emissions is calling for maybe an additional 500 to 600 gigawatts of wind and solar. Now, getting there is going to be hard. There are little things like building transmission lines, et cetera, but it gives you an idea what the stakes are here in continuing this revolution. So again, Ignacio, congratulations on a well-deserved reward. I should add that he is a producer not only of clean electricity and indirectly of clean hydrogen and clean vehicles, et cetera, but arguably more importantly, a great producer of jamón ibérico and wine. But to benefit from all three of his talents, you have to go to Spain, and I was certainly very pleased to have done that, and look forward to doing it again. I would just say that on the clean green hydrogen, in fact, today he emphasized again this idea of doing well by doing good. what a great market expansion for clean electricity that this offers. So I think combining good business model sense with the clean transition we need, the corporate governance commitments that we talk about, is really a benchmark. I will also just say that I think maybe today at breakfast I made a sale on turquoise hydrogen, but we'll see. We'll see if that's something that makes sense. So anyway, again, Iberdrola has been a real force in this area. Galan, I think in many ways has been the motive force of doing this. I think he's legitimately planetary and corporate hero in this sense. And Ignacio, we congratulate you again and invite you up to receive your Medal of Honor.
Oh, he's the wrong one? Oh, that's easily managed.
So thank you very much, everyone. I would like to start in congratulating Kerry and Luis Almagro for this medal. So I think it's, when I hear in your curriculum, I think it's nothing to see with mine. I think it's just, I'm just an engineer, which I was convinced that Kyoto opened an opportunity for trying to change the world, and I was working already in this direction for 22 years. So I think I would like to thank Ernest for your kind words. I think it's, we know for many years, as you mentioned, always has been already just a dream for me to be already in your position in the MIT, which you were with some of my colleagues. I was very pleased when you've been already nominated honoris causa in my Jesuit University in Madrid, which I think was a great day. So thank you for your words. So your determination when you were Secretary of Energy were crucial for already to move in the United States to climate action. So you were a pioneer as well. It was not myself, you were a pioneer trying to change the things. Those steps that you took already lead this country to be today a forefront of electrification through the renewable energies, networks, storage. At that time, you remember, even we have not already turbines. I think we are forced to build already a factory of turbines in Pennsylvania to supply your effort to decarbonize the electricity sector. So, and now I think all those things exist thanks to your determination. So as I mentioned, in my 22 years at Iberdrola, we have always been aware of the need to move towards a cleaner, secure, and efficient energy system. So I think that is perhaps my background of engineer to try to change the things. We committed to this goal before anybody, as you mentioned as well, and we were a pioneer. It was not easy. So I have to say that in my first board, when I tried to say that we have to close our coal and oil power plant and to invest billions of dollars in green energies, it was not easy. But even was more difficult, we said that we have to change the color of the company from blue to green. So I think that's why all we ask are wearing green ties. So when you see anybody with green ties, that is Iberdrola, because it was the most difficult decision. So, but I think, as what has been mentioned by General Secretary, I think the first thing we did is to try to change the company starting for values. So perhaps my Jesuit education is already conditioned myself on this direction. So values of ethics, transparency, solidarity, teamwork, responsibility, sense of justice, professionalism, etc., etc. I think we have a chart in the company in which we put very little numbers in our plan of 2001 plan. It's only one number, which is by 2. We plan to double the size of the company, but it's a full chart of values. So I think that is the first thing. So in one of those things as well, we understood the corporate governance will be the cornerstone of all of this. Without the proper corporate governance, will not work. I think I have to say that we have an excellent group of legal experts. We have already created this governance sustainability system, which was the foundation, as I mentioned, of our strategy, led by Julián Martínez Simancas, which is somewhere else here. So, where is Julián? And Santiago Martínez de Garrido. They are those ones who deserve this Medal of Honor. They have already made all these things for receiving this medal today. So I think our corporate governance system is based on the ESG plus F principles. I think it's constantly reviewed to reflect the international standard. And we try always to be ahead. So it's not already to do what is already in some places, what we can do more in this direction. So I think the implementation requires more than isolated effort from one company. I think we need already, for achieving the target of transition, we need already development of all agents, administration, institution, companies, the civil society. It's not a question of one to another, it's everybody to move in this direction. And I think I'm very pleased that this is already a better place than this United Nations to discuss how to work together to make a better future for new generation. I was taking note of certain of your comments about what has been said already. What we can do now, we can affect already to the future generation. I think we are, our vision in most cases is too short. We are looking for today's results, and I think we are not looking what is going to happen afterward. That's why I'm very pleased that jurists are already just looking and trying to defend the future generation as well. All the things related to the planet is crucial on that one. I think we have not a better planet. If we destroy this planet with today, we have not another one. So that's why we have to take care of it. So I think I would like to conclude thanking the World Jurist Association, and especially to Javier Cremades. I'm very sorry he cannot be with us today. I think tomorrow when I reach Madrid, I will phone to himself, and I wish a quick recovery for him. Unfortunately, he did, his accident. And just finishing, I would like to reaffirm my commitment to the energy transition. I think it's a process we can demonstrate in our companies. Then it's a process we are able to generate and create value for everybody. For those what we are living today and for those one we will be tomorrow. In the meantime, you generate wealth as well to the people which is living around. And I think as well my commitment to continue promoting the best practice in corporate governance and the rule of law. I would like to use just a word. Without a rule of law, energy transition is at risk. Thank you very much. Thank you.
Thank you, and let me add my congratulations to our three amazing awardees. Now, we're going to get a few closing remarks from the Honorable J. Clifford Wallace, who is the Chief Judge Emeritus of the United States Court of Appeals for the Ninth Circuit. Judge Wallace.
Thank you very much, Hillary. I thought I knew where I was going. I was supposed to bring together all of the awards until we got to the last speaker and award winner, and then I got off the track. I haven't had an awful lot of experience in that area, but when I was in the Navy, World War II, we do them by wars, I was an aviation electronic technician. And so I think that qualifies me to talk about some of the things that he was talking about. But truth be told, most of the time, when we couldn't get it fixed, we'd find that if you had a hammer and you hit it on the side, it seemed to start again. And so that became one of our major tools. And maybe sooner or later, you'll get to the place where you need to hit this car on the side with a hammer and solve some problem. Good luck on making that application. I've been surprised and pleased that the rule of law has come up so frequently in the discussions this morning, from the President at the very beginning focusing upon it, The first two award winners, we focus upon the rule of law, and should. That's what makes human life reasonable. That each person doesn't get to make their own decision. There are rules that we have to follow, and there'll never be peace. There'll never be rest until we are successful in implementing the rule of law. So how do we go about this? It's nice that what we're doing in the United States and in Britain and France, where there's an advanced rule of law, but the great majority of countries don't have an active rule of law. And I focus upon this because I came to the same conclusion some years ago. When I first left the lucrative practice of law and took upon myself the oath of poverty of being a judge, I focused less on what was going to happen today and was more worried about what was going to happen tomorrow. And I sensed at the very beginning the necessity of taking the rule of law and understanding that it's a process that we have to develop within a people. And I had some great experiences with my friends down in Mexico, with a great Chief Justice down there, Carlos del Rio, who made giant steps in developing the rule of law in Mexico. And I enjoyed it so much, I decided that I wanted to go elsewhere. And although I did not forsake any of my work, I earned my salary, I found that I could take time to go visit other countries and try to get them to see the rule of law. That was 50 years ago. And my first country was the People's Republic of China at the very end of the Cultural Revolution. And it was a mess. Every judge and every lawyer were sent out to the farms, and they used retired judges, retired military generals to be the judges. And that was the starting place. The president of the Supreme Court was an elderly gentleman that took naps all day. The vice president was an engineer. And he gave me an opportunity to look everywhere in China and make a recommendation. And I asked him at the very end, what do you want? What is your goal? What are you trying to achieve in a judicial system? And I'll do what I can to help. And he said, Judge Wallace, we want to develop a judicial system that can attract Western investment. He was an engineer. He understood that the People's Republic of China was failing, and the only way he could turn it around was to get investments from the outside. And that started my relationship with China, still do. I owe him the Chief Justice of China has invited me back for a new thing that he wants to discuss. And now, over the last 50 years, I've worked in 72 countries in helping them develop the rule of law. It's a piece-by-piece work. It's an education. It isn't something you can magically do, but it takes patience. And I applaud the American Bar Association, who's developed programs to assist using valuable time of volunteers, lawyers and judges, to assist them, because there's no wand. Every one of them is different. And it doesn't happen overnight. You have to continue to work with them. And yet, isn't that the goal we're trying to achieve? Isn't that where we're going to eventually bring peace to the world? Isn't that where we're going to eventually have every person be able to stand up equal, no matter their status or how much money they have or how many people they know, and be treated equally with everybody else, the rule of law? And to me, that's what unifies us as lawyers and judges, because we can see the goal we want to achieve. It's been a great ride going to these various countries and work with them. Have I retired? No, I'm still a judge, a senior judge, in which I make a decision how much work I'm going to do. Have I retired from overseas? No, I've made some promises to the People's Republic of China. I have also a promise that I made to the Russian Federation and the Ukraine. We can continue our work step by step, never giving up, taking our defeats, learning from them, and moving forward. The rule of law is what we can best achieve and what we can best contribute to making the world a better place. And I congratulate the recipients of these awards for their astounding work in these areas. Thank you very much for having me.
Thank you, Judge Wallace. You are an inspiration to all of us. Please continue your work for another 50 years.